So given what we know about the environment, we do have essential documents that all couples should perform. These include a power of attorney, a healthcare proxy, a disposition of remains form, and a will. And I'll talk about each one in detail. Now, if you have questions about any of these, again, please don't hesitate to ask, and we can continue our discussion. The power of attorney is the most powerful document a human being can willingly execute in America. The only document or thing that's more powerful than a power of attorney is a guardianship, and you can't willingly give somebody a guardianship. You have to be granted guardianship powers by the court. Power of attorney allows you to willingly give somebody the power to act as if they were you. Now, my documents are always durable powers of attorney, which mean they're in force and effect the moment they're executed. Some people have used springing in the past, which means they wait for a certain event to trigger the powers, but I highly recommend against using that because then you have to wait for, say, a doctor to say, this person can't make their own decisions, now you can make decisions. Whereas if you're planning for, say, an accident, disability, and qualifying for government benefits, you need to start moving immediately because the clock is ticking. With the power of attorney, I like to limit the powers that are available by picking and choosing which ones are granted. This is important not just to control what power somebody else may be able to execute, but it also shows that you were of sound mind when you were executing the document. There's usually lists of powers, and I have my clients initial in each of the brackets, skipping the ones that they won't use, showing they have full capacity when they're executing the document and avoiding any claims of undue influence in the future. In 2010, in September, we had a brand new statutory short form power of attorney in New York State, which is great because we had a brand new statutory short form power of attorney in New York State in 2009 as well. And I could go through the document piece by piece and talk about how silly a lot of the things in there are, but what I've done and what I recommend you do is just take the short form and add enhancements. I like to draft what I've found is useful that you're not going to find from just downloading a form off the internet. When you're executing this document, you designate an agent. This agent is somebody who's going to act for you according to your instructions. Well, you can give instructions, and in your best interests when you can't. Best interest, there's a lot of case law as to what does that define. We're making case law day to day on that as well, especially with the new document. And you have your backup agent who will act when your original agent is either unwilling or unable to act. The new form does not revoke prior powers of attorneys. The old form used to, so as soon as you signed a new one, your old ones were all invalid. Now it doesn't revoke that, which is important because if the new one is lost or destroyed, you can rely on your old one, but it's also something to watch out for because if somebody who you don't want to be your power of attorney is on the old form, they're still able to act. Now I put in a little bracket that we can execute that says, please revoke all my prior powers of attorneys. But that's just one of the little areas where you have to check and be sure.